that's not it. Good morning. My name is Chris Giovinazzo. I'm an attorney and a partner at the private law firm Bondurant, Nixon and Elmore here in Atlanta. And I'm here today to give a webcast on responding to subpoenas, how your organizations or you personally should respond to a subpoena, including a little bit of information about what a subpoena actually is. Now, I'm doing this in connection with the Pro Bono Partnership of Atlanta, which I think all of you are familiar with. The Pro Bono Partnership of Atlanta is a 501c3 nonprofit that works to connect attorneys in private practice with nonprofits and folks in need who need free legal services. And so I can speak for myself and my firm, but really most attorneys in private practice have both an obligation and an interest in serving low-income communities and nonprofits when they get an opportunity to do that. And what the Pro Bono Partnership does is helps connect those of you who need those services with those of us in private practice who are the right fit for a particular task and who can help. It's a great organization, and my firm has been hooked up with very rewarding and hopefully helpful opportunities many times. Just to give you a little other intro information before we start on the main event, in order to get assistance from the Pro Bono Partnership of Atlanta, you have to be a 501c3 located in the Atlanta area that serves low-income or disadvantaged individuals. That's the basics. I assume that most of you know that and hopefully have had an opportunity to use these services. And here on the slide that you're looking on now is the information for how you can contact Pro Bono Partnership of Atlanta. Oh, I'm sorry. I've mixed up my slides. What instead I think you're looking at is the disclaimer piece where we emphasize that this presentation is not itself legal advice. It's just sort of for your background. It's to try to assist you in understanding what to do in the stressful and sort of confusing event that you get a subpoena, which I understand that many of your organizations do. Okay, so I'm going to start with the basics, which is what is a subpoena? And before I get into the substance, I want to encourage everyone. I understand that you can see a chat window on the right side of the screen. By all means, if I say something that's confusing or if a question occurs to you that is related to what I just said, go ahead and type that in, and there's a way we have here for me to get that message. We'll also have time for questions at the end, but it's a good idea to ask them when they come to you. So let me start by saying, what is a subpoena? It's probably a word that you've heard in movies or TV about legal events, but I know I certainly didn't know what a subpoena was until I got to law school. And what a subpoena is, it's a legal command. It's a formal legal document, but it's one that is issued by a litigant, in other words, by a party or their attorney who is involved in litigation. And when I say litigation, what I mean is it could be a criminal case, someone who is being prosecuted. It could be a lawsuit. It could be some other legal procedure, such as an investigation by a government agency. So what the subpoena is, it's a document that tells someone, we need something from you in order to pursue or move forward with our case. It could be either documents or it could be testimony. And the important thing for you to know is that while these documents, and I'm going to show you some examples so you get a little bit of a better sense of what they look like, while these documents may be written by or come from private individuals, or you may not know who it is, it may not come from a government agency directly, this is an enforceable legal document. You can be found in contempt if you ignore it. And that doesn't mean you have to do everything it says, and we're going to talk about that, but it is a legal enforceable document. And I'm going to go into that in a little bit. The first thing you need to do when you receive a subpoena is recognize that it is a subpoena and read the key information on it. And what are the key information? First of all, you need to know who issued it. Where does it come from? Who is it that is asking for something from you or your nonprofit? and what is the legal matter that is involved. So, for example, I get the impression that many of you work at nonprofits that serve um, victims of assault or sexual abuse or domestic violence. You may get a subpoena in a variety of ways. It may be related to a criminal matter um, connected to the acts of violence, or it could be a custody dispute, which in legal terms, that's a civil matter. It's not someone going to jail or threatening to go to jail. It's a dispute between two private parties, or it could be a lawsuit. So I'm sure there are other varieties, but you want to know immediately who is issuing this and for what case. The second question is, who is the subpoena demanding something from? And I think the key question here is whether it is directed at a person, as in a man or woman, or a entity. Is it directed at your nonprofit, or is it directed at you or one of your employees? This has a lot of legal significance about what the obligations are, and so you need to recognize that. And then, of course, you want to know what they want, and we're going to talk a little bit about that with the examples. I think it'll become clearer. Two things that you need to not do is do not simply comply with the subpoena. If it says, send us the clinical case file for so-and-so, do not simply put it in the mail and respond. In no case is that the right, even if ultimately those are documents they are legally entitled to, that is not the first step. And the other thing you need not to do is you need to not put it aside or ignore it or even procrastinate. In Georgia, you have 10 days to respond, which is obviously not a long time. And I mean 10 days, not 10 business days. You have 10 days. So you should assume, and there are exceptions to how long you may have, but the starting assumption should be you have a week and a half. And so you need to organize your thoughts and decide how you're going to respond quickly. Okay, let's look. This is in the abstract. Let me show you what a couple subpoenas look like so you can get a sense of what you're going to see. And one thing that's a little bit confusing is that even though this is a legal document, it is perfectly appropriate for an attorney to draft a subpoena. In other words, I as an attorney can write a subpoena on word processor, and as long as it fits the general format of what they're supposed to look like, it's a subpoena. So you need to be able to recognize what it will look like, even though they will not always follow the exact same format. But here's the general, and I'm going to give you 3 examples so you can see a little variety. And the one that we're looking at here, at the very top, in the center, it says what court the matter is before. In other words, this subpoena is being issued in relation to a case that is in Houston County Court in Georgia. And the name of the matter is in that left side where it says plaintiffs versus defendant, and it has the names of the different entities. So in other words, this is a subpoena related to a civil lawsuit from Flint against Windstream, 2 companies. Usually at the top or somewhere clear, it will say who is being subpoenaed. In this case, it is Utility Support Systems. It's a subpoena issued to a company, which would be parallel to a subpoena being issued to a nonprofit. Even though it says care of David Thompson, it is not a subpoena directed at David Thompson. It is a subpoena directed at the entity. The entity is the one that will be obligated to do something. And in the middle there, it's centered in bold. It says subpoena ducis tecum, which of course, because it's law, we like to use Latin for no really good reason. All ducis tecum means is that they want documents. So essentially, there's 2 things a subpoena could seek. It could seek documents, or it could seek testimony. I guess there's a third. In rare cases, a subpoena could seek an inspection. So, for instance, they want to go onto your premises and look around. I doubt that many of you will get a subpoena like that. So this one says ducis tecum, which means all they want is documents. What documents do they want? Well, you see at the bottom, after all that legalized language about where the documents should be provided and an address, it says all documents listed on attached Exhibit A. This is pretty common. There is going to be a list of the documents, sort of the description of what documents they want. You're going to want to read that carefully. Now this subpoena, if you see at the bottom, there's a signature by the clerk of the Houston County Court. But one thing you need to know is it is not always required that that a court official sign the subpoena for it to be enforceable. I, as an attorney in my cases, I can sign a subpoena, and just because I signed it doesn't mean that if you ignore it, your entity can't get in trouble in court. So, and this is really important because it is very easy to look at something that's a subpoena. It could look different, and you say, "Who is this guy? I'm not giving him any documents." And unfortunately, it may be the case that you don't have to give them documents, but it is not the case that you can ignore the subpoena. Okay, well, I'm going to look at it. I want to show you a couple other examples for how these can look. And again, some commonalities. This is a handwritten subpoena, and it is written on a form. So now, I'm an attorney, and so when I write my subpoenas, I usually type them up myself, but individuals can also go to court and get sort of like a sample form to fill out. The forms don't all look the same because different courts have different forms, but they will have these commonalities. See, this one at the top, it says this is in state court in Gwinnett County, and you see it's a witness subpoena. It says at the top. And here it's been handwritten, and again, don't let that fool you and make you think that this is not a legally valid document. This one says to whom, and notice here that it says it's to Sharon Hill, who is the executive director of a nonprofit called the Georgia Appleseed Center. And then it has an address. And so this is important because, in my view, this subpoena is written to an individual, Sharon Hill. It shouldn't have been. It should have been written to the entity, but that's important for the obligations it imposes. This one, I won't go belabor the point, but you got to look. This one seeks both her appearance and testimony and documents. And at the bottom, it's signed. This one's signed both by the clerk and under attorney of record. I'm sorry if I'm going fast, but under attorney of record there, it's signed by an individual, and then it says pro se on the back. Pro se, another Latin phrase, means that Mr. Dwight Allen does not have a lawyer and is representing himself. That's what pro se means. So that probably explains why this particular subpoena has a lot of problems. It is incorrectly filled out in a number of ways. The one I mentioned, that it's to an individual rather than the entity. And notice this one doesn't have anyone to contact on it. I'm going to give you one more quick example just to see the variety of what subpoenas can look like. This third subpoena is issued by a government agency. So in this case, a state agency of the state of Georgia Securities Division is doing an investigation. We've blacked out the matter, but on the left it says in the matter of blank, and that's the name of, it's not really a legal case yet. It's not necessarily before a court. It's a government agency. But again, it says subpoena, which is the key thing to look for, and it says that a document list is required. Again, the point is that these can look very different, but the keys to look for is, does it say subpoena? Who is it to? Does it want documents? If so, what documents? And is someone being asked to testify? So now let me go through a few of the legal requirements that are important, because if these legal requirements aren't met or are inadequately met, they can provide you a legitimate basis to produce nothing or to produce what they less than what they've asked for. And I'm not saying that's your goal, but I'm sure, I imagine that most of the time when you get a subpoena, you're concerned both about the distraction in the time and also about the sensitivity of what they're asking for. And so often you're trying to figure out, do I really have to do this? The first requirement, sort of the preliminary requirement for a subpoena to be enforceable, is that it needs to be served, which is a legal term meaning delivered to the person being subpoenaed in a proper legal manner. So you need to have proper service. And what we'll often find is that a subpoena will just be placed in the mail and sent to you. Well, in Georgia and also in federal courts, there are laws about what is and isn't proper service, and just mailing it is not sufficient. It needs to either be handed to you or it needs to be served by what's called certified mail, which I think you all know what that is. You go to the post office and get it, or statutory overnight delivery, which is a fancy way of saying FedEx. So they have laws about specific kinds of overnight delivery, basically something that you sign for is really what the heart of it, something that you can prove that it's been delivered. If they didn't deliver it that way, it's not valid. Again, That doesn't mean you just throw it in the trash, but it means that it hasn't been served properly. The other thing about subpoenas is if they are demanding testimony that you actually, you or someone from your organization sit down to testify, they, if the testimony is outside of your county, in other words, let's say that you are in one county and the court is somewhere else, then they are required to pay a witness fee, which is supposed to cover your mileage and the time that you take. The check has to actually accompany the subpoena, and if it doesn't, they just, again, don't ignore the subpoena, but that is a flaw that will make the subpoena invalid. The most important thing here, save everything that you got. I'm talking including the envelope or whatever materials came with the subpoena. Save it because you may want to be able to show what was and wasn't included. And if you do get a lawyer, they're going to want to see it. And so you just need to put these aside and put them in one place. Now let's assume that the subpoena asks for documents from your nonprofit. The first thing you want to do is figure out what documents you have that fall into the categories the subpoena asks for. And you'll notice I haven't talked much about getting a lawyer. I'm going to talk to you about that at the end, about when you might want to seek legal assistance. But one of the reasons I'm doing that at the back is because everything I've said so far, you can do and should do on your own before you decide how to respond or whether to get a lawyer. And the reason is, I can tell you right now, the minute you contact Pro Bono Partnership and you get hooked up with a lawyer, they're going to want to know all this. The first question they're going to have about a document subpoena is, well, do you have any of those documents and where? So you want to go find that out before you take further steps, whether it's to respond or to get an attorney. So one of the questions that I think comes up for nonprofits who may or may not have a formal office, you may have employees or volunteers that are part-time or come and go, is, well, do I really have those documents? So the question from a legal matter of whether you have the documents is one about both the documents you possess, so if they're sitting in your file cabinet, you have them. By the way, documents includes emails, it includes electronic documents, so if you're on your computer, you have them too. If they're in your email, you have them. But what if a volunteer of yours, you think, gosh, she might have some documents at her house, or she came in and did a volunteer intake for this patient and may have notes, I don't know. That is a fuzzy area, but the general rule is if you have a legal right, if your entity has a legal right to get the documents, then you have control over them. A simple answer would be, for example, if I received a subpoena for my bank records, it wouldn't be enough to say, well, I never printed out my bank statement. I have the right to go to my bank and get my bank statement, and so I have an obligation to respond to that. Now, the circumstances are going to be more complicated for you and your various relationship with the folks who help you and volunteer or work for your nonprofit. But I can tell you one thing, if you're the executive director and you happen to have some documents at your house, the fact that they're at your house is not going to make any difference at all. Your nonprofit has access to those documents. And again, it's going to get fuzzy with former employees or people you're out of touch with. But that's the basic framework. On the other hand, I think it is possible that you may have documents that are sitting physically in your office or the area that you keep your nonprofit's documents, but you don't really control them. For instance, if you have a volunteer who comes and does psychological services, for example, something confidential, but left her patient file in some place that you have access to, it's arguable that you don't have control over that without contacting the care provider. Again, I can't give you generalizations, but you should know that it is more than just documents that are sitting at your physical office. It is electronic things, it is email, and it is things that you can obtain by asking. Okay, so let's talk about some privileges, some reasons beyond the technicalities for why you may or may not have to provide documents. A law was passed about 2 and a half years ago called the Advocate Privilege Law in Georgia. And what it does is, I think it goes to the heart of what a lot of your organizations do. It says that if there is not a court order or consent by the patient slash victim, you may not be forced to produce documents or testify about things or providing documents that you acquired while providing services to a victim of domestic or sexual violence. So let me go through those steps one by one. The first is that this is the default unless the patient or victim consents. So if they say, yeah, they can get those records, it wouldn't apply. Or the court says, you know what, those records need to be produced. Now, the way this works is you will assert this privilege and say, no, we're not producing documents, and then they will have the opportunity to go to court and say, actually, we need them. And I won't go through the basis that they could get them, but essentially the court could say, these are critical documents for this matter. We will take appropriate measures to keep them of limited public availability, confidential. For your purposes, that all happens after you assert the privilege, and so you just need to know that the privilege may apply. The documents and testimony is defined broadly. What documents is anything you acquired while providing services to the victim. So the way I read that, it includes, even if it's not really what you might think of as personal services or sensitive medical, psychological counseling services, if it is, you ask them in the course of just their intake information or their whatever they gave you, that would be a document that is covered here until either there is consent or a court order. And I'm going to talk in a little bit about the logistics of how you assert these privileges. A couple other ones. There are some very strict federal victim confidentiality rules. These apply to any nonprofit that receives funds under the Violence Against Women Act, the Family Violence Prevention and Services Act, or the Victims of Crime Act. And these basically say, these are categorical. You may not disclose any personally identifying information, which in my mind would include even the fact that you saw a particular individual without a written release from the victim. Again, I'm going to talk about how you assert this privilege practically when you receive a subpoena. But if it says, I want Jane Roe's counseling records, and you are covered by these protections, I think the answer is whether or not we have such records, I can't tell you unless you had consent because of these confidentiality rules. A couple notes. If the claim is that the victim or the patient that you worked with has consented, always demand such consent in writing. You need to see something signed by the patient that says, I consent. Never take their word for it. You need to see that. Similarly, if the claim is the court has ordered that you give these documents, don't believe them, because they could just be referring in a strong-arm way to their own subpoena. That's different than a court order where an actual judge says, yes, go give them the documents. I overrule any objections you have to the subpoena. Okay, so see things in writing if someone makes a representation to you. The second thing is that the abuser cannot consent. So this would come up in a situation, for instance, where there is a child involved, a child who was allegedly abused in some fashion, and you counseled that child, and there's a subpoena asking for records related to your work with that child. The alleged abuser cannot say, well, they're a minor, I consent on behalf of my child. That's expressly taken off the table. The other thing, I'm sure most of you know where your funding comes from, but you need to be aware that you may get funding only from state agencies, but a lot of times the state agencies are really they're administering the funds under these federal laws. So that is something that, and you may know this already, but you can, and there may be easy ways to find out, but it may be the case that you say, well, I'm not receiving any federal funds, so I don't get to take advantage of this. That's often not the case, because your funds are actually tied to those federal laws, even if they are distributed by a state. How are we doing on time? Okay, great. Another federal law that you probably have heard of if you do anything in the counseling or healthcare providing sphere is HIPAA. I'm going to not remember what it stands for, but it's like the Health Insurance Portability and Accountability Act. Oh, all right. Which is a really 5 words that when you put them together don't mean a lot to me. But anyway, um, HIPAA's provisions that relate to subpoenas apply to healthcare providers. And I'm not in a position here to say whether you're a healthcare provider or not. Frankly, I don't know the law on that. It's complicated. I will say, though, healthcare provider is defined very broadly. If you provide services that are in the form of counseling for people who have mental health issues or physical issues related to abuse, for example, I think there's a likelihood that you're a HIPAA healthcare provider. But I can't say that I know for sure, and it would take a little more information. You may know. But under HIPAA, if you're a healthcare provider and a subpoena comes from an attorney or the clerk of court, which is basically all the subpoenas we looked at. In other words, if you look carefully at those subpoenas I showed you, no judge was signing those. Those were signed by individual attorneys, and maybe the clerk of court, by the way, is basically an administrator, not a judge. They are someone who works the file room and maintains the files for different cases. So if the subpoena comes from an attorney, which is what most subpoenas will come from, or the clerk, healthcare providers under HIPAA cannot disclose protected information unless the patient received notice and a chance to object. So what does that mean? That means that the patient involved in the records has to have they have to know about this subpoena, and they have to have time to object, or they can consent and say, I don't want to object, and you can give them the records. Now, again, do not take anyone's word for it that the person, she knows, she's fully aware of this lawsuit and knows we're coming to seek these documents. Yeah, well, that's not what I asked. I asked whether she consented to the documents. Okay, and if they say, yeah, she's fine with it, I want to see something in writing with the signature. Frankly, I'd really rather talk to her as well. Um, so. If there's going to be a claim that these confidentiality and privileges are waived or have been released by someone, you need to be awful sure about that. That's something that you do both for her and for yourself and for your own protection. So there's no argument later on that you gave away something you weren't allowed to. The other thing is, if they say something like, well, we don't know where she is, or we can't find her, you are free to say to them, hey, I can't say whether we've served that person or not, but then after that, reach out to them and say, you should know that this has been received. In fact, I would go so as far as to say is whenever you receive a subpoena seeking counseling or records related to a particular person that you served or counseled or gave healthcare services to, it's a good idea as a practice to contact them and let them know. They may know about the lawsuit. I mean, if it's a custody dispute or a lawsuit they may be a party to the suit, and they'll want to know. That's something that you can help them with, and you will have a better idea of what they did or didn't agree to. Okay, so let's talk, with that background, let's talk about the best practices back from the start again. You get this document that's a subpoena. What should you do? The first and most important thing is that you need everyone you work with, and I'm not just talking about employees, I'm talking about volunteers, to know that if they receive a legal document or a subpoena, who does it need to go to? I suggest it go to your executive director, but they need to know that that is an important document. It needs to immediately be transmitted to the executive director. And I can tell you, it will not be an excuse if you missed the deadline to respond that Jimmy over here had it and he didn't know to give it to someone else. If the organization got it, the organization got it. I'm simplifying, but that's really the basics. The other thing that you need to remember is, and I talked before about whether the subpoena is correctly addressed to your organization. If it's an address to a person, I mean, for one thing, like let's say it's addressed to the executive director or a particular counselor that helps you. I mean, I don't think they don't have any right to take your documents or testify on behalf of your organization. So you need to make that, be aware of that immediately. And of course, you want to read the subpoena and look for the things that we talked about earlier and figure out whether or not you have any documents in the first place. Okay, so once you've gotten the lay of the land, you figured that you've got the subpoena and what it's seeking and whether you have it. The first thing that you do to respond to a subpoena is you object. All right, you could call it responding, objecting. Basically, you're saying, I've gotten this document, and here is the problems we have with it as an organization and what we may or may not be able to do. You have 10 days to do this, and you do not need a lawyer to object. But as I said, this may be something you feel very uncomfortable doing without a lawyer, and if that's the case, before the 10 days run out, don't wait till day 9. Contact the pro bono partnership and figure out if there's a lawyer who can help you. I'm just telling you that you do not need to a lawyer to do this, so you do not need to feel hamstrung and in a position where, well, I can't respond, but I can't get a lawyer. What do all I can do is give them these documents. That is not the case. You are perfectly capable of communicating your objections without a lawyer. Here are the objections that are most useful and most critical to assert. The first one is, we don't have any documents. You've asked for some documents, we don't have them. Parallel to that is, if such documents exist, they would be with, Jody, who counseled with us years ago. I don't even know where she is. We don't have any control over that. The other related objection would be, I don't really understand what you're asking for. You say all records related to so-and-so. I don't know what you mean. Okay, so you can say that. The second thing you can say is that the subpoena is burdensome. And this is sort of a placeholder to say what you're asking for is unreasonable to bother a small nonprofit like ours with, for instance, if, I'm not going to go back and find all my emails with every patient. The subpoena we showed you earlier asked for what really sounded like all documents that the nonprofit had ever created. That's a little different than a patient-specific subpoena, but it's worth saying this, frankly, even if maybe it wouldn't be that incredibly difficult to collect the documents, you always want to say that it's burdensome because it helps narrow the scope of what you end up having to do. Third is the subpoena was improperly served, which is that legal term I used for whether they delivered it properly or gave you the witness fee, or they didn't give you enough time. Enough time especially applies to testimony. If the subpoena says, I need you in court on Friday to testify, that would be something you want to say immediately. Now, the lines on that are fuzzy, how much notice they need to provide, but generally speaking, because you have 10 days to respond, if they're trying to get you to testify any sooner than 10 days or even longer than that, you want to say that. And finally, you want to assert the privileges that we went through, okay? You want to assert all of them. Frankly, if you don't know if you're a HIPAA healthcare provider, assert that HIPAA's confidentiality applies. That can be resolved at a later time. I mean, don't make things up. Don't say things that you know to be not true, but you want to construe the privileges broadly. And of course, I haven't talked about some basic privileges here that apply, which is just sort of like the patient doctor privilege. I don't know if that would come into play, but there are some basic privileges, spousal privileges, for example. So you want to just assert broadly that the documents may be privileged, and if you know what privileges, some of them are in these slides, just say these are all something that comes up. And the best practice is when if you do this yourself, don't promise anything. Just say, I've received your subpoena. There's a number of problems we see with it. Okay, it's burdensome. We don't think it was served on the right person, or it was served on a person rather than our entity. It wasn't served properly. It was in the ordinary mail. We don't know that we have any of these documents, and most of what you're seeking is very sensitive and subject to a bunch of privileges. All right, that's where you start. Don't say at the end, but we'll get you documents. All right, you have then ensured that you do not run out of time, or a court comes and says, you got this legal subpoena and you just ignored it. Okay, and as a practical matter, if that's all that you do, and they still want documents, they are now in the position where they have to go to the court and say, these objections are wrong, Your Honor. We have a right to these documents. Okay, you've put the burden on the other side. Okay, now testifying is a little trickier. It's the same idea, but it's a little riskier to simply not appear at a court hearing, as you can imagine. Um, you may want to talk to a lawyer specifically about that even before you object. But the idea is that by objecting in writing, you have turned the burden back on the people who want something from you. Sure. We have a question. That's a great question. Yes, you do not need to do anything to. The question was, what is the sufficient and correct way to object? Do you need to send it just to the attorney or send it to court and so forth? The answer is you do not need to do anything in court to object, and that is why you can do it on your own behalf. Um, the court doesn't want to see the objections and may never see them. For instance, it is very possible that you will object, and when they get the objections, the attorney, I mean, the other side, they'll just give up, and that'll be the last you hear of it. That happens all the time. I don't want to bother with it if that's the case. So if you saw on those example subpoenas I looked, the proper thing to do on the subpoena is to have a list, contact information for who to contact. If it's signed by an attorney, it's easy. You want to send the objections to the attorney, always in writing. Send them. You might want to send them in multiple ways. If you have an email address, send it by mail and by email. And this goes without saying. Everything you do, make a copy of. Okay, keep a copy of what you send them. If you end up producing documents, don't give them. By all means, do not give them your only copy of documents. Okay, and if, for instance, you have to give them something that you had to go find, like let's say emails, and you printed the emails, keep a copy of what you printed so you don't have to recreate the wheel. Everything you did, you keep. But the answer to the question is all you need to do is in writing respond to the attorney. Now, as I showed you one example, sometimes the subpoena is issued by a person who is representing themselves in litigation. This happens a lot in family law because lawyers are expensive, and if people are having a custody dispute, for example, they may just not be able to afford a lawyer. And so you may get a subpoena from an individual. That creates challenges, but the answer then is if the subpoena is just from the individual, that's the person that you need to send your written objections to. And I can tell you that most people, when they are representing themselves and fill out a subpoena, they do something wrong. It's easy to do. They send it by mail or whatever. So that's something. Objecting is something you can do on your own. Are we on the next slide at this point? Yeah. So there's nothing that requires you to speak to anyone speak orally, I mean by phone, about the subpoena. But I can tell you in my practice, I always reach out. Now, it may be the case that what you do is you first send the written objections, and then you wait to see if they give up. If they give up, then you certainly don't want to call them and remind them about the subpoena. But if they don't give up, or even before you object, it is often worthwhile to call the attorney. A little bit riskier to call the pro se person because they're usually going to be someone who's emotionally tied to whatever the case is. But if it's an attorney, you can call them and say, "Hey, I'm not an attorney. My organization got this subpoena. What is it that you want?" And one of the reasons we often ask what you want is because lawyers have a tendency to write overly broad. I want every document that relates or concerns or has anything to do with, and it's very, very vague. And if you read it literally, it could mean thousands of documents. And if you call them, they'll be like, "Well, actually, my client says that your client brought in this one, mortgage document from their house, and they can't find it anywhere else, and that's really what we want." Oh, well, if it's a mortgage, you can often cut through a lot of the wasted time by finding out what they really want. The same is true on testimony. What do you want someone to testify? We have a lot of concerns about testifying. The call, you can also ask whether the person, if the documents or testimony relates to an individual client of your nonprofit, you can ask whether they've been contacted, whether they know about the subpoena, and whether they've consented. This is a polite way to also inform them of those um, duties before those privileges can be waived. And you just say, this is a chance to say, look, I'm not trying to say I'm going to ignore your subpoena, but this is extremely sensitive what you're asking for, and there's a lot of legal privileges that apply, and I'd be surprised if you have a right to this information without a court order or consent from this person. Okay, so you can get a lot. You can ask for extra time is another thing we do all the time. As much as there are deadlines in the law, if the issuer of the subpoena says, you can, I'm not in a rush. You can have a month. Um, no court is going to put you to task for taking a month rather than 10 days. The key is that if you have this conversation, do not make promises on the phone. Do not make promises. Do not say, well, okay, in that case, we'll give you those documents. Give yourself time to think about that, even if that's where it's going to go. Don't make promises. This is the chance to say, look, I'm a reasonable person. We're a reasonable organization, but what you've asked for is really confusing and broad and a pain, and probably you're not entitled to it. So work with me. People will be responsive, and you can often get away with giving them 1/10 or 1/100th of what they want, what they've asked for in writing, if you don't simply take it on its face and say, well, this is crazy. Um, I would recommend that if you have such a conversation, this is something I we lawyers do, and it's rather irritating. But